Well, good morning, everybody. What a great day and a nice way to finish up our season. My name is Tommy Johnson. I'm with the Portland Regional Chamber of Commerce, and welcome to Eaton Peabody's Growth Basics for Business. This is our monthly seminar series, which provides a forum to gain useful do-it-yourself workplace solutions and insightful, actionable tips. We are at the end of our 2021 event season, and this is the final Growth Basics event of the year. As we look forward to returning to in-person events in the fall, I want to recognize and thank each of our virtual presenters that we've had over the past year. They've really, truly been outstanding. Today's topic, Startup Success, Legal Q&A with Eaton Peabody, is presented by Rebecca LaPierre and Johanna Colpritt, both associates at Eaton Peabody, as well as Katherine Porter, Senior Counsel at Eaton Peabody. We are very fortunate to have them with us today. Now, like all Chambers virtual signature events, today's presentation is free, and it will be recorded and made available for free replay on the Chamber's website and YouTube page. To keep up to date on all of the Chamber's news and events, please visit our website, portlandregion.com, check out our events page, and sign up for our weekly email newsletter while you're there. Now, before we get to today's presentation, I would like to remind you that if you have questions for our presenters, please type them in the chat box on YouTube, and I'll be able to relay them to our presenters throughout the event. But at this point, I'd like to acknowledge our presenting sponsor of Growth Basics for Business, Eaton Peabody. For the past 3 years, Eaton Peabody has been the exclusive sponsor of this event series. And I'd like to announce that next season, we will be coming back for this event series with Eaton Peabody as a sponsor again. And at this time, I'd like to invite Marketing Manager Nate Levesque to say a few words. Thanks, Nate.
Great, thank you, Tommy. I can't believe that this is the end of our third season. I want to thank the Portland Chamber for doing such a great job of putting these together and providing new and engaging content month after month. Whether this is your first Growth Basics event or your 10th, I want to thank you for taking the time to join us today. I'm pleased to be joined by my Eaton Peabody colleagues for a great presentation. For those of you that may not be familiar with our firm, we are a full-size, Maine-based law firm with nearly 50 attorneys serving Maine clients from offices in Augusta, Bangor, Brunswick, Ellsworth, and Portland. We assist companies of all sizes, so whether you're an established financial institution or a small business taking your first steps, we can help with all of your legal needs. To learn more about the services that we provide and the industries that we serve, please visit our website, eatonpeabody.com, and also be sure to follow us on Facebook or LinkedIn to stay up to date on legal updates and future presentations. Thank you, Tommy.
Thank you, Nate. And again, I cannot wait to get back into live events. And I say this every month, it seems like a broken record, and Nate knows what's coming. But once we do get to be able to meet again in live in person, don't miss these events, if only for the breakfast that Nate puts out there. He brings the best treats and the best coffee that we have at any of our events. So well worth the time and investment. But without any further ado, I'm really pleased to introduce our panel of presenters today. First, we have Rebecca LaPierre, and she returns to Growth Basics this season after facilitating a presentation on how to run a successful internship program back in December. Her practice focuses on a range of labor, employment, immigration issues, including management, defense, ADA, sexual harassment, FMLA, employee handbooks and discipline, and discharge, discrimination, whistleblower actions, employment-related investigations, collective bargaining, employment-related contracts, and employment and family-based immigration, all critical to startup organizations. Johanna Colpritt's areas of focus include business formation and structuring, mergers and acquisitions, angel, venture capital financings, securities offerings, general corporate work. She is based in the firm's Portland office, but frequently travels to and works with those in the Bangor and Ellsworth offices. And we have Katherine Porter. She represents the private and public employers in all aspects of labor and employment matters. She routinely advises clients on federal, state, and local employment laws, including discrimination, sexual harassment, retaliation, accommodations, leaves and wage and hour, COVID-19 compliance, whistleblower, and misclassification issues. Take it away.
All right. Thank you so much, Tommy, and thanks, Nate. So as Tommy said, my name is Johanna Colpritt, and I am a business attorney here at Eaton Peabody. So I'm just going to go ahead and jump right in. If you're watching this, it's probably because you're wondering either where do I start, or I have started, but I'm not sure how to keep going, or even possibly I've been, a business in existence for some time, but I'm wondering what that next step is. So I would suggest on the next slide, if you don't mind, Becca. So beginning with the business plan. So before you consult an attorney, I highly suggest you gather your thoughts. So what is it that your business is going to do? What's the purpose of it? In other words, so you're forming a business to rent property? Are you forming a business because you have developed a great product that you want to sell to customers? Are you forming a business because you have a skill set and a service that you want to offer to clients? Figuring out that purpose and narrowing it to whatever its true purpose is the first step. Then you want to figure out, what's my goal? Do I want to be a relatively small business in a small town? Do I want to create a business that has potential to grow exponentially, whether it's within the state or the country or even internationally? Keep that in mind when you're starting your business. Who's going to be involved? We'll get further into this as I talk about the different structures in which you can form your business. But is it going to be just you? Are you going to have friends? Are you going to have family involved? Do you have a business partner, a third party? Are you going to have employees? Are you going to have consultants, contractors? Think about that. Also, of course, we all wonder, how am I going to fund this business of mine, right? So do I already have capital on my own that I've been saving? Do I have family and friends that are willing to contribute to this business? Do I need to go speak to a lender and, talk about loans? Or perhaps I want to go seek out, other investors, whether that's angel investors or venture capitalists or whoever it may be. And then, of course, the timeline. So once you have all of these things in mind, amongst many others, you want to think about, all right, what do I want to accomplish in this week even? Or what do I want to accomplish in 6 months, a year, 5 years, 10 years, whatever that may be, at least come up with a timeline and a plan. Of course, that's most likely, I can almost guarantee, going to be adjusted as you move forward. But having an initial place to start is good. All right, and this is just a very brief shout out to all of the other resources in Maine. Of course, this is only a few of them. There are several others, and to those I apologize that I did not necessarily include here today with my limited space. But another suggestion I have is, working with attorneys is great, but it's also good to use some of these other resources that are either low cost and or free. They've gone through hundreds of other people that have been where you are, and they really know how to help this startup stage component. All right, so now is it time for an attorney? So when you're considering whether you need an attorney, I can tell you, you probably do. One thing that I like to disclose up front to a lot of people that are contemplating whether they need legal services or not is that it is much easier and much more affordable if you have an attorney at the outset and do things, right from the beginning, as opposed to trying to do too much on your own and then having to seek an attorney after the fact to fix some of those things. And an attorney can help you with a number of things, right? So one of the things I'll touch upon after this slide is, what kind of entity are you trying to form? Are you trying to form an LLC? Are you trying to form a corporation? Are you trying to start a business just as a sole proprietor? Perhaps a partnership. So an attorney will help you walk through all the considerations that go along with that. All right, let's jump ahead. So, like I said, you need to figure out what type of entity you want to form. So there are a lot of factors that go into making this decision. You need to think about how many owners there are and what kind of owners they are. Are they individuals? Are you going to form other entities? Are you going to have a holding company and subsidiaries? In other words, a parent and subsidiary companies. Well, again, what's the business purpose? Are you looking to scale? Are you looking to stay relatively small? And of course, the two biggest, perhaps three biggest considerations really, I would say, are the tax structure. How do you want to be taxed? Do you want to be a pass-through entity? Do you want to, have the option to make an SCorp election, perhaps? Second is the exposure to liability. And I should also just point out that this is not first, second, third in terms of importance. These are just some of the major things you should consider. So back to liability. You really want to limit your liability, and choosing specific types of entity structures creates much more protection. And then finally is also the management of your business. So do you want to be restricted by certain laws and statutes, depending on whether you're formed in Maine or perhaps you're a corporation formed in Delaware? Do you want to have more flexibility? Do you want to be able to draft a partnership agreement or an LLC agreement that has, particular provisions and nuances that are unique to your business goals? And we'll talk about each of these individually now. So, a sole proprietorship. I'm not going to spend too much time on this because like myself, I'm sure many of you have actually formed a sole proprietorship without even realizing it. So you can think of a sole proprietorship as a business that you run by yourself. It takes absolutely no special filings with the state. There may not be any special, and most likely there aren't any formal agreements. I like to think of it as a lemonade stand, perhaps, in your neighborhood as a child. If you were out there and you had your product and you're selling to your, the friends and families in the neighborhood, those are your customers, you had a sole proprietorship. The problem with the sole proprietorship is that there's no protection from liability. So you are the business. You personally and individually are the business. And anything negative or damaging that results from the business is going to be on you, which exposes your personal assets. And then from a tax perspective, this is neither good nor bad. It depends on your circumstances. The income and losses from the business will just flow through right onto your individual tax return. So again, that middle point there, there's no separation. If you are a sole proprietorship, it is you and you are the business. Partnership is really just, I guess a way of thinking about it is it's a sole proprietorship almost, but two, right? Combined. So a partnership can be formed as easily as Becca and I saying, tonight, let's go form a business and let's form our own lemonade stand, but we want to grow it. So we're gonna have two partners now. So again, nothing formal needs to be filed with the state. And you may decide to have a partnership agreement drafted. I would recommend that if you do go this route, just so that the partners, it's clear what your voting powers are, what the allocation of income and loss is going to be to each of you for the business, management, things like that. And there are different types of partnerships. You can have a general partnership in which everyone is a general partner and you're all equally liable. You would have a limited partnership, which would mean that you would have some, perhaps, a general partner and maybe several limited partners. In which case the general partner is typically responsible for the management, day-to-day operations of the business. And the limited partners, perhaps they just help with certain major decisions, or they're help contributing capital, whatever that is, they're usually not involved in the day-to-day. With partnerships, liability is, again, it's a risk. So you are personally liable if you're a general partner, like I mentioned, and you may also be jointly and severally liable, depending upon how the agreement is and how your partnership is structured. And again, similar to a sole proprietorship, partnerships are what we call pass-through entities, meaning, again, the income and loss from the business passes through onto your individual tax returns. All right, and we have now got an LLC. So many of you have likely heard of a limited liability company. And these are very popular right now. And in the grand scheme of, all history of corporate law, they're relatively new. They're, like I said, very popular. And they're really a combination of partnerships and corporations. They basically take the best components of each of them and combine them. So with a limited liability company, you will have owners, which we refer to as members, and you may have managers, which would manage the day-to-day. With that being said, a limited liability company can be member managed if it is going to be managed directly by the owners. Or like I said, you can hire outside managers, perhaps employees, whatever that may be. You have that flexibility in terms of your management style. You are not personally liable. The LLC is its own person under the law, its own entity. Therefore, you have protection. So if you're a limited liability company, something happens in the business, something damaging, and the LLC is liable, your personal assets are protected, which is one of the major benefits of this entity structure. And in terms of taxation, again, huge benefit. You have a choice. So do you want to be a pass-through entity? Do you want the income and loss to pass through to those member owners onto their individual tax returns? Or do you want to elect to be taxed as a corporation? I'm not a CPA. I am certainly willing to advise on certain tax considerations and aspects. But I do like to always just reiterate to clients that you should consult with your accountant before making some of these choices, because there are many, many considerations that come into play when you're deciding what the optimal tax structure is. And next we have C-Corps, corporations. So these are one of the most traditional, long-standing types of businesses. They're probably what you think about a lot when you think of business attorneys or corporations, corporate attorneys. These are entities that are absolutely, again, their own person under the law. They are completely separate from the owners. Similar to what we were discussing before with limited liability companies and members being owners, you will have shareholders in a corporation, which are the owners. So that's the hierarchy. We start with shareholders in a corporation. It then comes down to perhaps the board of directors. Again, that's a management style decision. And then you'll have your officers. And your officers are responsible for the day-to-day operation. The board of directors oversee those officers, and the shareholders have certain rights, and whether it's voting perhaps or rights to distributions. And corporations are, they're much more structured in that they, similar to limited liability companies as well, you file with the Secretary of State a certain form applicable. So for a limited liability company, it would be a certificate of formation. For a corporation, it would be articles of incorporation. You will then have a document that I highly recommend you have an attorney draft, and that would be your bylaws, and that's your governing document. So that may cover things such as officer roles, such as voting rights, such as transfer restrictions on ownership. What happens if certain people want to dissolve a corporation? What needs to happen? What kinds of decisions can the day-to-day managers make without having to go to a higher authority? Things like that will be covered in the bylaws. And then some corporations also choose to have a shareholders agreement. And that's totally a choice that you can walk through with your attorney. It depends on how many different nuances you want with your business, how many shareholders are involved, what kinds of shareholders there are, what the property involved in the business is, another option. One of the best, probably the best actually, component of a corporation is the limited liability for owners. So again, corporations, they are separate, they're distinct, they are their own person under the law. They can sue and be sued, and your personal assets will be protected. And then in terms of a tax perspective, C Corps have less flexibility than limited liability companies. You cannot be a pass-through entity as a C Corp. You are subject to double taxation. And what that means is that the corporation would be taxed initially when it earns income. And then the shareholders will be taxed second when they receive distributions or dividends. So the next chart is this comparison chart, which I'm just going to touch upon because we are relatively short in time. There's a lot to get through here. This is just a breakdown of the different entity structures that we talked about in terms of the formation piece, liability, taxation, and financing, which I will talk about financing as we move along. This is just a nice synopsis. That's all I'll touch upon on that. So you might be wondering, for those of you who have perhaps already done some of your research, you've talked with family, with friends, with consultants, third parties. Well, she didn't mention anything about S-Corps. So S-Corps are another option. However, the reason I separate S-Corps is because from a legal perspective, an S-Corporation is not something that we form from, initially. So the way an S-Corp works is you will choose to form perhaps an LLC, or perhaps you choose to form a C corporation. Once you form that by filing, like I said, the certificate of formation or the articles of incorporation with the Secretary of State, you will then decide to make an S election. And that's just a form. It's called Form 2553. And you form that with the IRS, electing to be taxed as an S Corp. There are many tax advantages to be taxed as an S Corp, but there are also certain requirements if you want to be taxed as an S Corp. So there are, limitations on what kinds of shareholders can be involved, individuals, trusts, things like that. There are restrictions on how many shareholders can be involved. And then there are also restrictions, amongst others, on the classes of stock that you can have in your corporation. So preferred stock, voting stock, common stock. You can only have one class of stock. So it's less flexibility, but there are certainly benefits to making that S Corp election. So, as promised, where's the money? Where am I getting the money to fund my business? I have this great idea. I have this great product, great service. How do I fund? How do I fund the capital? And there are, there's many options. I like to break it down, at least from a basic initial startup perspective of two routes. So one of those options is debt financing. And debt financing is what you probably typically think of when you think of financing a business. It's loans, it's borrowing. And when you do this, you may be borrowing from family and friends. You may be borrowing from a bank, a traditional, lender. There are many advantages and disadvantages to going the traditional debt financing route. For example, when you get a loan, you're not giving up any control or ownership of your business. It's simply, well, I shouldn't say simply that. In general, you have your loan document, and it's really just a promise to pay back the money that you are now receiving. And once you've paid that off, whatever the term of that loan is, your hands are clean, and you're all set. In terms of disadvantages, you do have, this is money that you do have to repay. So you may get a loan at the outset of your business, and you may not know exactly how the business is going to play out, successful, not. You've created this obligation now, and you will be obligated to pay it back. You may also, from a perspective as a startup, may be asked to make personal guarantees on the loan in order to obtain it. And that's relatively common. I see it often. And so, that's something that you need to weigh, whether you're comfortable doing that or not. The terms may also be subject to change. So it's always helpful to have an attorney that you're working with review the loan documents, make sure the terms make sense, whether they're locked in or they're subject to minimal changes. You want someone to take a look at that. And the other option, kind of broad scope of financing options, is equity financing. And what this is you are essentially receiving perhaps it's cash, traditionally cash, in exchange for giving up a piece of ownership in your business. So, for example, you may be seeking angel investors, or you may be seeking venture capital financing. Perhaps, often now people are using crowdfunding as another method. And so with equity financing, you have the potential to raise significant amount of money, depending on what your product is, your service is, and whether that is scalable. Again, advantages and disadvantages to both of these options. So with equity financing, you have greater flexibility. Often these investors that are contributing cash and capital in exchange for ownership in your business, they're invested in your business now. So typically they come in because they have certain expertise or experience. You may bring someone in who has experience with marketing, or someone who has a financial background or has connections in terms of international growth. Whatever that is, they are going to bring that to the table because they have a stake in your business now and they want to see it succeed. In terms of disadvantages, one of the most obvious is you're giving up ownership. So something that you may have owned 100% or 75% or 50, whatever it may be, you now own a little bit less. And that's something that you need to think about. And then there's also, it can be costly, it can be time consuming. It depends on how complicated your structure is going to be, who's involved in terms of investing, the amount of money that's being invested. And so that wraps up. And again, that is a very, very quick, basic overview of entity structures and financing options. I may just pause there briefly to see if there are any questions.
As of right now, no questions coming in from the audience.
Great. All right. So now I'm going to touch upon intellectual property. And this is a very interesting area of the law. It is constantly developing as we modernize in today's world. So I'll just quickly say, before I really dive into this, that businesses in general have three major types of property. So you'll have your real property, and that would be your building, your parking lot, things like that. You'll have your personal property, and that is things like office equipment, office furniture, inventory. And then of course you'll have your intellectual property. And these are things like your formula, your brand, your name, your process, your methods, things like that. And these are vitally, vitally important. I think that sometimes because we can't touch, physically touch or physically see in front of us intellectual property, it gets lost in the midst and people tend to forget about it. But it can be incredibly valuable to your business. It can perhaps be one of your most valuable assets. And it's something that you need to jump on from the start. So, looks like the slide's a little funny looking. Sorry about that. So the first type of intellectual property I will touch upon are trademarks. And this is probably one of the types of intellectual property that we're the most familiar with. So a trademark is your brand. It may be a word, a phrase, a symbol, a design, whatever it may be. It's what distinguishes your goods or services from others' goods and services. And the way that you establish a trademark is use it. Simply and consistently use it in commercial transactions. In addition to that, you certainly can, and we would highly recommend that you do register your trademark. This can be done at both state and federal levels. And that essentially, it gives you the right to use the trademark registration symbol. So that little R with a circle over it, which will discourage others from infringing upon your trademark. And it also gives you the right to use that trademark nationwide on your goods and services. Very, very quickly, I will just give some examples of trademarks that you are very likely familiar with to paint a picture. For example, names can be trademarks. So when you hear the name George Foreman, you immediately think of grills. That's an example of a trademark. Designs can be trademark. So the Nike swoosh is one of the most obvious, or perhaps the golden arches for McDonald's. Again, they're very common. People immediately know what that business is when they see that design. And something as simple as a particular color can be trademarked, a particular sound, scent, A packaging, perhaps for an example, you could have a perfume bottle that has a very, very unique design, and you can trademark that design. And then one thing I do want to touch upon before I move on from this, I am moving pretty quickly here, but is very important, the distinction between a descriptive or attempting to have a descriptive trademark and having a distinctive trademark. A mark that is descriptive is not going to receive trademark protection. Things like that literally use words that describe what your product is. So on the slide, you can see log cabin homes. It's not going to receive trademark protection. It's too general. As opposed to, if you look at the other end of the slide, you have, suggestive, you have arbitrary, you have fanciful, things like that. So arbitrary would be, it's a word that we use in everyday use, but when you trademark it, it applies to a specific product or business. So for example, when you think of the term apple means a fruit, but in a trademark perspective, Apple suggests computers or iPhones. And then, even further are fanciful terms or marks. And those are words, marks that did not exist prior to a business establishing them. So like the word Nike has no other meaning other than what that business is now. And we associate Nike now with running sneakers, athletic apparel, things like that. Moving right along to patents. So patents, this is a right that's granted by the US government to an inventor for a limited time, and it essentially excludes others from making or using, offering for sale, etc., the invention that this inventor has created. And it also excludes others from importing inventions into the US for inventions that are protected. So a patent needs to be useful, it needs to be novel, and it needs to be, I should back up. The invention needs to be useful, novel, and non-obvious in order to receive patent protection. And by that, I mean it needs to have a very specific useful purpose. It needs to be original in terms of novel. So no one can have created it before. It can't have a previous patent on it. It needs to be non-obvious. So it can't be a very minor substitution that you make for something else that someone who is familiar in that area or that industry would have thought to be obvious. There are different types of patents. Some of the most common are utility patents as well as business method patents. And these typically include, machinery inventions, biological composition inventions, business methods that you create. You can also have design patents. So these are, manufactured ornamental designs, perhaps like a smartphone case. You can get a patent protection on that. And with patents, again, the dates are critical for getting patent protection. So the first to file receives the rights. So this is one of those things where if you think that you're going to be creating something that you can get patent protection for, seek an intellectual property attorney to help you get that done. Once an invention is publicly disclosed, you have 1 year to get that application in. And then depending on what kind of patent you have, utility patent, design patent, depends on how many years that protection will last. And copyrights. So copyrights, this copyright protection is something that is used for original works of authorship. And when I say authorship, it can be one author, it can be several authors. One of the most important things as a startup business, when you think that you might be developing products or services that may receive copyright protection, is this created by one of your employees, or have you hired a independent contractor to develop perhaps software or code or whatever it may be? You want to make sure that you are consulting with an attorney to make sure that the correct agreements are in place to ensure that the business will have the rights to that material. So we typically do this with a services agreement, or work for hire language is what we call it, assignability agreements. And those are something that you need to get in place prior to the initial creation of these products. And you also want to make sure that these agreements outline the scope of whatever the employee is doing or whatever the independent contractor is doing, so that it is very clear that this is going to be something that is being developed for the business and will be the right of the business. And then on the right here are just some different types of things that can receive copyright protection. Literary works would include things like books, periodicals, publications. Things like dramatic works are screenplays, screenwrites, etc. And sorry, I'm moving along very quickly. This is a lot to get in. To trade secrets, this is a little bit different than the last three we talked about, because you don't actually register a trade secret to save it. So a trade secret is a business, financial, technical information that you as a business have kept confidential through reasonable means. And the fact that you have kept it confidential and it has not is not known generally gives it that economic value. So examples of this would be the recipe for Coca-Cola, the soda, or the recipe for KFC's fried chicken. Staying away from food and beverages. Another example is the source code for Adobe's Photoshop. So things like that. Really what's important to do here is, if you do have employees that are privy to the information that relates to the trade secret, you want to make sure that confidentiality agreements are in place, non-disclosure agreements are in place. People aren't sharing passwords, there are policies in place with your employees. And anything that is a physical hard copy is locked up and stored safely. That's how you protect your trade secrets. And the last thing I will just say are the key points: plan early, file timely, and consult an attorney. And that is not an order in which you need to do things, of course. I would probably suggest that you consult an attorney first, in fact. But all of these things are vital to the success of your business long-term, and you will benefit tremendously by getting on top of it right at the beginning.
Great. Well, thank you, Hannah. Do you want to check and see if there are any questions at this point?
Yeah, no questions thus far. Hannah, great presentation so far. So I'll let you guys take it away.
Excellent. Okay. Well, my name is Katherine Porter. I am an employment attorney here in Eaton Peabody's Portland office. I work routinely with Becca on employment issues, and we often work with startups here in the state of Maine. So we really should call this Employment Law 101 for startups, because employment issues are huge for our clients. And so I'll just sort of run through what we go over here. Classification of workers. We want to make sure that people are properly classified to avoid liability and to get ourselves prepared for diligence with investors. Documenting the relationship. Should you put pen to paper to show exactly the terms of your engagement with these folks? Do you need HR? We're cost conscious, especially starting a business. So do you need to engage someone, whether counsel or an HR professional, to help guide you through these issues? Notices, posters, policies, employee handbooks. Do you need them, and what do you need? And then we're going to focus on telework. In the past year, something we all have experienced often and know intimately. So what are some tips with telework? And then finally, we'll just touch briefly upon employee benefits. It's not necessarily our specific area of expertise. We have colleagues that specialize in that, but something we want to flag for you all. So the first thing I ask clients who are in the startup area is, who do you work with? And tell me about them. And the reason why is I'm trying to figure out how we classified folks, because there's serious risk involved in getting the classification wrong. So the first question is, are these individuals employees or are they independent contractors? And really what that inquiry boils down to is, who is exercising control over the relationship? In Maine, we actually have a statute that specifies the criteria for folks to be properly classified as independent contractors. And you'll see we've copied the test. It probably goes into a couple of slides there, but there are 7 factors that you actually have to satisfy. So that's going to be Does the independent contractor have the right to control the means and progress of the work? Do they have their own business? Do they have the opportunity for profit or loss? Do they employ people to help them provide services, and some other factors? So you have to satisfy all 7 of those. And then there's some additional factors that you have to have at least 3 of them to satisfy this test and be properly classified. In sum, it's a high bar, and it's best to engage counsel. And Hannah touched on this. It's important, even though it's expensive or it is an expense, to engage counsel at the outset to help you sort of lay the groundwork and make sure that you're properly classifying folks. So you have employees, obviously different than an independent contractor. The terms and conditions of their employment are set by the employer. So they're subject to a tighter degree of control than an independent contractor who may have their own business and provides a specific service to a variety of businesses. So that is an important inquiry. The next is, all right, let's assume we have an employee. Are they non-exempt or are they exempt? Non-exempt employees are those folks who are eligible for overtime under federal and state wage laws. That means that if they work more than 40 hours in a week, they're eligible to be paid time and a half for any hours worked beyond 40. And it also means that employers really should take the initiative to have those employees track their time. This becomes important because if you have a dispute with an individual who's non-exempt and they say, I worked overtime I worked 60 hours a week and they didn't pay me for those overtime hours, you want to be able to go back and say, that's not correct. We have these records showing that, they only worked 41 hours and we paid them for all that time. Now, if you have an exempt employee, that person is going to have to be paid the salary basis. Now, that's going to be the higher of the federal or state salary basis. That means in Maine, $36,000 a year in year 2021, this year. And they also need to qualify for one of the exemptions to overtime under federal and state law. That commonly is going to be someone who's an executive, a professional, administrative exemption. Now, I'll just use the administrative exemption as an example here because I run into this a lot with startups. This is someone who in their role exercises independent discretion and judgment over matters of significance. That means that they're able to run with their duties. They don't have to keep going to someone to have them sign off on everything they do. Oftentimes, an administrative assistant really should be non-exempt as opposed to exempt. That's not always a hard and fast rule, but it tends to be the case. An exempt employee could be someone who is a high-ranking HR professional or marketing professional. But of course, job title is not determinative, it's substance. So again, like the independent contractor question, it's important to engage counsel to make sure that you're applying this test properly and that you've classified folks as either non-exempt or exempt in accordance with the law. And the last thing I run into with startup clients is, well, we've got interns, of course. And the question really becomes, well, are they paid or unpaid? And what is proper in light of wage laws? The general rule is that interns should be paid unless they qualify for these exceptions as more of a trainee. So maybe they're getting educational credit for the internship, and the internship and what they're doing is high level, they're observing, it's educational, as opposed to something where they're moving the ball forward for the company and actually working on programming or even making copies. All of that is work that's typically done by employees, and therefore those interns should be paid at least the minimum wage. And because they are non-exempt, generally, they should be paid any hours in excess of 40 hours worked in a week. Why is this all important? Classification. Well, it's important because it can expose the client's significant liability down the road. Now, it could be tax liability if you misclassify an independent contractor who should really be an employee. That's because employees generally have withholdings applied to their paychecks. The employers pay into certain tax and benefit pools for them. So this is really important to get that classification correct. Also, there's wage liability. Let's say you had someone classified as exempt and they should be non-exempt. We find out after the fact that they've worked a lot of overtime. That's a real risk because under applicable law, that means if you have a wage claim, you could be subject to treble damages, so triple the unpaid the value of unpaid wages and benefits, as well as attorney's fees. So the costs escalate quickly, and it's something we should really try to get right from the outset. The other risks involve investigations by governmental agencies. I've had situations in the past where someone was classified as an independent contractor. They were terminated, or their engagement was terminated by the employer or a business startup, and that person then went to file for unemployment. And that typically would definitely happen in this environment we're in. And then the Department of Labor started to investigate, well, what was this relationship that this worker actually had? Were they really an independent contractor, or should they have been classified as an employee? And so apart from liability, which we've just covered, you also, as a startup, are looking to get investors. And this is what Hannah talked about with equity investing. You know, you want folks to be interested in your company, invest in it, whether it's equity or otherwise. And so as part of making those investments, we have to do diligence. And so questions about classification of employees is a huge topic. And so it's best if you can engage counsel, get these classifications right from the outset to make sure that when you do have that diligence down the road, you will look like you have all your T's crossed and I's dotted. So next slide. So now we've determined whether or not someone's an employee, independent contractor, exempt, non-exempt, and should we document it? I would say you should. And that's because you want to avoid disputes. Having an agreement that sort of sets forth the terms and conditions of either the employment relationship or the consulting relationship is helpful to refer to if there is a dispute. And often in the diligence process with investors, they're going to ask for documents. Do you have offer letters with employees? Do you have consulting agreements? And it's really helpful if you can say, yes, we have. It's again, that same crossing your T's and dotting your I's, looking really professional and attractive to investors. So in employment agreements, generally, I include an at-will employment statement. And that's the de facto status of employment in the state of Maine. That means that either party can terminate the employment relationship for any reason and at any time. Sometimes we do have situations where you want to lock someone in for a certain period of time. That's usually going to be a high-ranking executive, like a COO. And so they'll agree to work for 2 years for a certain amount of compensation. And that's a term agreement. And those are definitely something you want to discuss with counsel, because there's particular provisions about termination, what are the rights upon termination that we would want to spell out in an agreement. Then you want to set forth what's the pay. Are they going to be paid salary, hourly rate? Do they need to track their hours because they're going to potentially be eligible for overtime? Are you going to pay them a discretionary bonus? If so, be clear that it's discretionary. Is it guaranteed? If the bonus is guaranteed, what happens if they leave at some point? Are they paid a portion of that bonus, or do they forfeit it? Then we want to talk about benefits. What are they potentially eligible for in terms of insurance, health benefits? Of course, the plan documents govern, but sometimes we like to say what they could be eligible for. Will they be eligible for paid time off, sick leave? So we like to spell that out. And then the most important thing, which Hannah did touch upon, is restrictive covenants. Startups are breaking out into the business space because they have a great idea. They have a special sauce. We want to protect it. Now, that's going to come in the form of confidential information covenants, which sometimes need to have carve-outs depending on the industry and applicable law. You also want to have an intellectual property provision, which Hannah touched upon. That is critical. We want all intellectual property that's created by an employee during employment to be the property and IP of the startup going forward in perpetuity. And then we also want to think about non-solicitation of customers, clients, and employees. You've put together an important team to bring this baby forward, and you don't want to lose them. So that will depend on the law that governs the relationship. For example, in California, non-solicitation restrictions really are not allowed. In Maine, they're allowed, subject to reasonableness in terms of length and the actual restrictions itself. Then the last thing that's often brought up to us by our clients is, can we include a non-compete for this employee? We want to make it so that if they leave, they resign, we terminate them, they can't go work for a competitor for a period of time after they leave. And that really depends. I mean, we've all seen that non-competition restrictions are coming under increased scrutiny. There's more statutes governing exactly how they can be imposed upon employees. In California, there's essentially a ban on non-competition restrictions with some limited exceptions, for example, in the sale of a business. In Maine, we actually do have a statute that governs non-competes. It has restrictions on, exactly what types of employees can have non-competes. So there's a certain income threshold. There are also restrictions on notice periods for non-competes and limitations on when they're actually enforceable and can be imposed upon employees. So again, very important to get counsel involved in drafting these agreements to make sure that what you have there is enforceable and would not, for example, void the agreement because it's not enforceable. And the last thing that we want to think about is choice of law. And this does tie into the restrictive covenants. Generally, not as a hard and fast rule, but generally, the choice of law that I select is exactly where the employee is working. For example, if you had a Maine-based startup that's working with a California employee, so they're going to be traveling to the Portland office, for example, or the Bangor office from time to time, but performing the majority of their services in California, under California statute, they actually have to have California law apply to the agreement. There are some limited exceptions, but it's very narrowly tailored. So the choice of law matters, and it matters in terms of the restrictions that you can impose upon that person, how they're paid, and this ties into what Becca will speak about, but the types of posters that need to be provided to them and notices. So definitely when it comes to drafting employment agreements, I'd recommend consulting with legal counsel to make sure that what you've got on paper is working for you, is enforceable, and is really what you need. So then we've done employment agreements. They're really important. Consulting agreements, should we have them? I think you should. And the reason why is, again, we want to set forth exactly what the payment terms are, what sort of services you expect them to provide and they are agreeing to provide. But really what I find to be important is I want representations in that agreement that that the independent contractor understands and agrees that they will be responsible for paying taxes and that they have insurance, adequate insurance, that you will not have them covered by your workers' compensation insurance, for example. So I think that's very important. Again, you also want to have some restrictive covenants in there. And I think what's most appropriate is preservation of confidential information and the company's intellectual property if they're working on IP for you. Intern agreements, should we have them? Definitely. Just like an employment agreement and a consulting agreement, we want to be clear about what the terms of the engagement are. And specifically, I want to state expressly that the internship is not a guarantee of future employment, and that these folks are non-exempt employees generally that will be paid for any hours worked over 40 hours in a week. So I guess we can go to the next slide. We've talked about classifying the workers that we work with, how we should document that, what we should do. And then the question is, okay, so we've done all of the things that we need to do for diligence to avoid liability, hopefully. What's the role of HR? Should we do anything else? And you really should. As we all experienced in this past year with the pandemic, employment issues are sort of front and center in how businesses are run these days. They're complicated. For example, how to deal with reasonable accommodation requests in light of vaccination requirements and coming back to the workplace. Those are really tricky inquiries. And having someone who understands exactly how the law works and how to handle those inquiries so that the business folks and startups can focus on the mission at hand is critical. In engaging either an HR professional or definitely legal counsel, you're going to minimize your liability, be proactive about getting ahead of the laws, and be able to stay focused on actually getting the business day-to-day items done without stepping into landmines of liability. So this person can help you deal with, for example, requests for reasonable accommodation, the interactive process, and what we should do about the request. They can also help you manage developments in the law. So we had obviously COVID compliance requirements from federal and state guidance that you had to take into consideration, OSHA issues that have come up, also whether or not to how to deal with mandatory vaccination issues. Should you have a mandatory vaccination policy or not? Also, earned paid leave in Maine came out somewhat recently. Does that apply to your business? And if so, what do you need to do? So it's really important to engage with someone who can help you navigate the employment complicated landscape. And as we sort of note here, there are different laws that apply to employers of different sizes. So it's great to have someone who, as you grow, ideally as a business, can tell you, okay, well, it's time for earned paid leave. We actually have to do that now. And in Maine, earned paid leave law requirements only kick in if you have 10 or more employees. Are you subject to the Maine Family Medical Leave Act? If you have 15 or more employees, yes. And hopefully you get there. So all of this is super important to understand what your obligations are and to protect yourself, because obviously the goal for a startup is to, world domination and to grow the business. So distractions with, employment issues, liability, and having to deal with more rigorous diligence, employment diligence with investors because we didn't get it right from the get-go. That's just something we'd like to avoid. So tell me, are there any questions at this point?
No questions coming from the group.
Super. Well, I will turn it over to Becca, who is going to talk about notices, posters, and employee handbooks. Thanks.
All right, and I know we're just about out of time, so I'm gonna kind of hustle through this. A lot of this is, something that if you're really building a business, if you're hiring employees, you should be reaching out to an attorney or to a consultant to work on some of these, because they can become quite niche issues. And it depends on how many employees you have. As Katie mentioned, some laws kick in once you get to a certain number of employees, and most startups maybe aren't going to get there right away. So you might have a little time. But just to kind of quickly cover some of these things, when you do start hiring employees, there are certain requirements under both state and federal law, including for notices and posters. And then we want to talk briefly about employee handbooks. Now, you might not think that's super important right at first, and maybe you only have 1 or 2 employees, but there's certain policies that you actually have to have no matter how many employees you have. And then there's certain policies you really want to have no matter how many employees you have. So for notices and posters, there are legal requirements about what posters need to be included in your business place, as well as where they need to be posted. If you've got remote employees, how you're going to get those posters and notices to those employees. So one of the things that is important to remember is that there's actually a website from the state of Maine, which is maine.gov, of all the labor posters that are required for various businesses, and some only apply to some businesses, some apply to all businesses. But those are going to be your minimum wage posters, your sexual harassment poster, your Whistleblower Protection Act poster, workers' compensation posters, child labor posters, things like that. So in certain businesses might also need an OSHA poster. You might need something related to paid leave, FMLA leave, depending on how many employees that you have. And these posters are notices for the employees that include sort of their rights, the employer's obligations, and it's our job as an employer to make sure that employees know what those rights are. There's also training requirements in Maine once you get to a certain number of employees. If you have 15 employees or more in Maine, you do have to provide certain sexual harassment and non-discrimination trainings in terms of harassment. So those are things that you're going to, again, once you start building your workforce, make sure that your business is aware of these things. You can hire consultants or attorneys to come in and provide those trainings for you. We do those trainings here at Eaton Peabody, and we're happy to come to your business and provide those trainings if they are required. An employee handbook, yes, you do want one. There are certain policies that are required, specifically sexual harassment, whistleblower protection policies that you do need to have. There's also a number of policies we'll recommend, and I'll briefly go over those in a minute. But the most important thing is that having good, consistent policies that are reflecting reality is your best way to protect yourself against an employee-related claim. If you say, I've got this policy, the employee has been aware of it, they signed it, and we're consistently enforcing it, that's a good protection and a defense against an employee claiming that you're doing something wrong. Your policies need to reflect the reality of your business, not your ideals of what you would like your business to look like. They should be consistent with reality and what's actually being enforced in reality, because if your business is doing something opposing to your policy, that's actually potentially going to be evidence against you in the event of a claim. So make sure that you tailor these handbooks and policies to your business. I would recommend you consult an attorney or have an attorney draft you your initial handbook. You can find them online to buy or to download. I don't recommend those necessarily because they're sort of one size fits all, and that's never a reality in a business. There is no one size fits all for any business or for any employee pool. So some of the posters I mentioned that are required, so are going to be your minimum wage, sexual harassment. Like I said, they're online. You can grab them, print them, download them. If you have remote employees, you're going to want to figure out, do you have a portal that they can be accessed on? Can you email them to all of your employees? And if you have a physical work site, you do actually have specific requirements about where you post those so that both employees and applicants can see them. Your handbook, again, it's not a one size fits all. It's going to depend on your business, but some of the things we recommend for everyone are an equal employment opportunity policy, non-discrimination, harassment, or retaliation, in addition to sexual harassment, Whistleblower Protection Act policy. There are, again, specific requirements for some of these. I would recommend that if you have a policy or a handbook, have your attorney look it over. Make sure that you are in compliance with the requirements under the law. You're going to want that overtime policy. And as Katie was talking about, definitions of your exempt versus your non-exempt employees. It's really easy, especially for starters, to just say, oh, they're hourly versus salary. That's not actually the case. It's not just about how they get paid. It's about how they are classified as an employee. And if you misclassify them, as Katie mentioned, you can end up with some pretty tricky claims against you and end up with some financial risk. So make sure you have those definitions in your policy and make sure that you are complying with them. You're going to want to have a policy on reasonable accommodations, something on wages, meals, and rest periods. There is a requirement in Maine that you provide a rest break for employees who work 6 consecutive hours or more. It's a 30-minute rest break for meals, and it can be unpaid. If you're going to offer breaks that are shorter than 20 minutes under the FLSA, those do need to be paid. And if you're going to have folks traveling, you're going to want to look into travel pay and travel time to see if that's compensable time as well, and make sure that you have a clear policy on that. Paid time off, as Kitty mentioned, earned paid leave in Maine is required if you have more than 10 or more employees. You're going to want to have a policy on that, on FMLA, or any other applicable leave, such as domestic violence leave or military leave. Make sure you have something showing that you are complying with those laws. So one of the things that's a big topic for startups and now lately for everyone is teleworking. You're going to want to have a teleworking policy if you have any employees who are working remotely, working from home, working out of state. And that's important because otherwise you can get into some trouble with it. So if you do have remote employees, if you're hiring folks who aren't coming into an office, make sure you have a very clear teleworking policy. And especially if you have folks who are coming into the office or working from home, you want to have a clear policy, because that's where it gets really tricky, is when they're doing a little bit of both. You want to make sure you are able to track hours for non-exempt employees. If you're not tracking their hours and you're not paying them appropriately, you're going to end up with a wage and hour claim. And if they say, you know, oh, well, I know I was only supposed to work between 9 and 5, but I actually logged in from, 7 to 10 and did 3 extra hours. Now you owe me 3 hours of overtime. And you're like, well, I didn't approve that. You still have to pay them for it. You could have a policy that says they're going to get disciplined for working extra hours without approval, but you also have no way to prove that they didn't do that if you're not tracking their hours. So that's very important for a non-exempt employee. And generally, we do recommend that you only permit exempt employees to work remotely just because of that complication. There are pros and cons to teleworking, especially for a startup. The pros are going to be that you have less overhead, you don't have to pay for office space, but you have to remember that there's also less control over the employees. You have less ability to supervise your employees. It's harder to track their time, for example. But you also then have a greater talent pool. You could reach out to anyone in the country or possibly in the world, but then you might have, immigration or other tax concerns that you want to consider. So, where the tax implications are really important. Where are these people working from? Do they have to pay taxes in the state that they're working in, or where the business is? And what taxes do you have to pay as a business if you've got folks working in state and out of state? There's also state law implications. As Katie mentioned, there's conflicts of laws, and sometimes the state where the employee works will be the laws that apply, and sometimes it's going to be the laws in the state where the business is, and sometimes it's going to depend on what's in your contract. But it can get very complicated, and you want to make sure that you are clear about what laws you have to follow, especially with regard to employment, as they vary drastically from state to state. There's workers' compensation concerns. If someone isn't set up appropriately with a workstation, you're going to want to have a policy that clarifies what that workstation consists of and what part of their home or their home office or wherever they're working is covered in terms of workers' compensation, because you don't want to be responsible if they, cut their finger with a knife while they're making lunch in their kitchen. But you will have to be responsible if, say, they hurt themselves because they're not in an ergonomical setup, and hurt their back because they're working in a weird position or something. There's employee morale implications, and those can be good things and bad things. On the good side, you have more flexibility. It helps with recruiting. A lot of employees want to work from home, so remote work can be very enticing. On the other hand, there's less of a sense of community in the workplace. You don't necessarily have that sense of camaraderie and morale building and teamwork building that you might have if folks were in the office. And then really quickly, lastly, employee benefits. Like Katie said, this is not our specialty. We wanted to stick a quick note in here for our employee benefits folks at the firm. If you need advice on employee benefits, please contact Ed Feibel, Jack Bajorn, or Ann O'Donovan, in the Portland office. They are excellent attorneys, some of the best employee benefits attorneys in the States. And a quick note for them is that if you are building your employee pool and your business is getting bigger, the ACA is going to kick in once you have 50 or more employees, and COBRA is going to start applying if you have 20 or more employees. Most startups aren't going to get there right away, but hopefully you will. And once you do, you want to be aware of those things. And you can provide benefits before you get to that point. If you want to provide benefits for employees, it's just only required in terms of health benefits once you get to those numbers. But again, please reach out to one of our employee benefits attorneys if you do have questions about what you should be doing or when or how many employees you need to have in order to be required to cover those. And so that is the end of our presentation. Sorry, I just kind of blew through that. And also apologies to my colleagues. I was responsible for the PowerPoint, and somehow it got very wonky on my computer. So I'm sorry for the discrepancies there.
Well, Becca, thank you so much. And thank you to both Hannah and Katie. What a great presentation. And to all of you, including Nate, thanks again for just another great presentation and event today. Just a quick reminder that today's presentation has been recorded and it will be available for replay, available on the Chamber's website and the YouTube page. Additional details and resources will be included in the post-event email you'll receive later today. Just a quick plug for some upcoming Chamber events. Mark your calendars for Thursday, June 24th at 4 p.m. for our final Kegs and Issues of the Year, New Manor Workplace, a stronger, more inclusive solution. And also on Wednesday, June 30th from 9 to 10 a.m., join us for a virtual reopening roundtable. What will reopening your business look like? Thanks again for another great season of Eaton Peabody's Growth Basics for Business and for attending today and throughout the year. We look forward to seeing you in the fall. Have a wonderful summer.